Good afternoon. My name is Renison Jeffrey, and this is the Workers' Rights Platform. We are broadcasting live from the Workers' Rights Network. Now, during the course of this morning, we would have picked up on an argument that was displayed by Ramesh Lawrence Maharaj in concerning his client, Foster Cummings. And, this might be boring stuff to some of you. But the argument that is presented here by the attorney, we would have feel that it is necessary to play it outside here within the public domain. So this here is the introduction concerning that, and we go into it. Now, a little history about what would have taken place on within May 2022. Some information would have leaked concerning a special branch report with Foster Cummings, and he would have taken action as to sue the state as per damages. Now, many of us would have known, ought to know Ramesh Lawrence Maharaj. He's one of the lawyers that have been practicing law for over 50 years in Trinidad and Tobago. Just a little backdrop about Ramesh Lawrence Maharaj. Ramesh Lawrence Maharaj is a Trinidadian and Tobagonian politician and lawyer born on September the 16th, 1945. He has 50 years experience in the legal profession and was admitted to the practice at the English bar in 1967, and was also been admitted to the practice in St. Vincent and the Grenadines. St. Vincent, the Grenadines and Grenada. So this Ramesh Lawrence Maharaj is well established as to where law is concerned, not just Trinidad alone. Ramesh has always been involved in various roles in politics, including serving as a member of parliament, an opposition chief whip, and attorney general and minister of legal affairs. So again, that is part of his accolade. He has piloted several laws promoting openness, transparency, and accountability in governance. Ramesh Maharaj have also been involved in landmark cases, including Ramesh versus the Attorney General of Trinidad and Tobago, which deal with the fundamental rights and freedom. He has also been married, and he had 3 children. Now, concerning what would have taken place, as to give you a timeline, as to the argument that we are going to play up next as to what would have taken place with the case with Ramesh Lawrence Maharaj. On May 3rd, 2023, Cummings' attorney would have written the TTPS asking for the records to be corrected. So he would have written on May 3rd, 2023. In July 10, 2023, a second letter was sent to the TTPS. On August 7, 2023, a response is received from the TTPS Service Legal Unit asking for extension. So they would have written them back asking for extension on August 21st, 2023. No response have been received, and a follow-up email is sent. So they send that. On October 18, 2023, a pre-action protocol letter was sent to the Attorney General as respective as a representative of state. On October 2023, the 23rd, the Attorney General responds stating that the state cannot be liable for disclosure of information unless the minister can provide names of the officers responsible for the leak. Now, what was interesting about that is that that was explained within that same very video that you are seeing up there. In December 4th, 2023, the Attorney General reiterated that the state is not liable for the disclosure of the information. So Foster Cummings, he want to receive vindication as to what taking place. Foster Cummings was the Minister of Youth Development and National Service, has been embroiled in a controversy surrounding a leak of a special branch report containing allegations of unscrupulous business activities. Here is the details and an overview as to what that was. The report dated June 5th, 2019 was compiled by the Special Branch of Trinidad and Tobago Police Service, the TTPS. It contains several allegations against Cummings, including that he conducted unscrupulous business through two companies contracted to the Housing Development Corporation, AGC. The report has been leaked by Senator Jayanti Lakshmi Dial, who read it out on a political platform on May 2022. So again, we would have thought that it is necessary as to play the entirety of the video there. As you could see for yourself, the arguments that would have been laid by as to why Mr. Maharaj would have think that it is vital to vindicate the very said minister. And we urge you to subscribe to the channel and be a part of this fastest growing network. With that, we are going right in to the video.
Mr. Ronnie Bisessa, attorneys at law Ricky Harnanan, Mr. Kingsley Wallace-B, attorney at law, Mr. Varun Gopal Gosain, attorney at law, and Mr. Nicholas Sant. I've not seen him here as yet. The purpose of this media conference is to inform the public of a grave injustice which has been done to a Minister of Government, Honorable Minister Foster Cummings, the steps which have been taken by him in order to redress that injustice, and also the steps which he now intends to take to achieve justice. Before I go into the summary of the matters, I want to give you an overview of what I'm going to talk to you about. This is an important issue, in my view, which affects every individual in Trinidad and Tobago, because what happened to Minister Cummings can happen to any individual in Trinidad and Tobago. A secret branch report of the Trinidad and Tobago Police Service was compiled in 2019 against Minister Cummings, in which there were serious allegations of wrongdoing made against him, but he was never given the opportunity to answer any of those allegations. And that secret special branch report was in the exclusive and sole possession of the Commissioner of Police and the head of the special branch. The contents of that report, however, ended up in the hands of an opposition senator, the Honorable Senator Jayanti Lakshmidiyal. And that senator published the contents of that report at a public party political meeting. So it meant that the serious allegations of wrongdoing against Minister Cummings were then in the public domain, although he did not get any opportunity to answer those allegations. The special branch note, which has been described as a report, consists of 1.5 pages. It had on it, in red, secret. The allegations in that report were baseless. They were uninvestigated. There was no evidence to support any of the allegations, and there was no person identified in that report as making any allegations. The note, that secret special branch note, therefore, merely consisted of allegations which were hearsay allegations which would not be admissible in any court of law. Upon the contents of that report being made public, being published to the whole world, in 2019, the minister then takes steps to file a defamation claim against the opposition senator. That defamation claim is pending before the High Court, and that issue will be determined. In that claim, he's saying, his claim really is based that the allegations which were published were untrue, they were false, and they were baseless, and they defamed him, and that he's entitled to damages, including exemplary damages. We would deal with that at the time of the trial, but it's just part of the history of this matter. The minister wanted accountability for the wrong which was done to him, quite apart from the claim he filed against the senator. He wanted accountability from the state. That is to say, how it is that a secret special branch report, marked secret, ended up in the hands of an opposition senator who then published it at a public political meeting. So what did the minister do after being advised what to do? We, on behalf of the minister, wrote to the Commissioner of Police, pointing out the injustice which has been done, and in respect of the allegations contained in this 1.5-page note, we answered every allegation in about 7 pages, pointing out that each of those allegations were untrue, they are not supported by any evidence, and we are asking the Commissioner of Police to correct the records of the police service, because that note, that special branch note, then became part of the official records of the police service. Section 36 of the Freedom of Information Act gave to the Commissioner of Police the duty and the power and in order to correct that report, and the correction could include even deleting the entire special branch report. That application was made to the Commissioner of Police in May 2023. Now, the special branch report was compiled in 2019. It was published by the opposition senator in 2022. And the application to correct the record was made in May 2023. The Commissioner of Police in 2019 was Commissioner Gary Griffith. Now, I am not saying that he had anything to do with the compilation of the report, because the report was compiled by the special branch, but it was sent to the Commissioner of Police, to the Office of the Commissioner of Police. He left, he was no longer Commissioner in 2022. And so when the report was published, he was no longer Commissioner of Police, as far as I can see from the record. But very important, in 2022, he gave an interview on I-95.5 radio station, and that the answers he gave in that interview are very important, because he was asked specifically about this secret special branch note. And he said that that note contained no evidence. It was just an intelligence report, and it contained no evidence. So you have the Commissioner of Police, who was Commissioner of Police in 2019, 2020, and he would have seen that report. He would have known what the police had, and the Commissioner of Police said it had nothing. It has no evidence. It had nothing. But notwithstanding all efforts we have made as lawyers to get the holder of the Office of Commissioner of Police to correct that report, we have been unsuccessful. As a matter of fact, you would see when I give you the summary of the facts, the Commissioner of Police acknowledged the receipt of our letters, promised to reply, and never replied. And up to today, this report, which was published in 2019, which was compiled in 2019, up to today, no police officer has interviewed Minister Cummings about any of the allegations in that report. So what Minister Cummings was saying, I do not want you to stop your investigations. You could investigate how much you want, but until you conclude your investigations, take off all those defamatory things, baseless things from the records of the police service. When you finish your investigations, and if you find you could charge me for any offense, you could put it back. But until you could get anything, as Commissioner of Police Griffith said, it has no evidence in that. Correct it. But for some reason, they have not corrected it, and it doesn't seem as though the Commissioner of Police intend to reply. So the question which arises, that here you have a minister of government whose reputation was damaged by a report which was in the sole custody and control of the state. And that report ended up in the hands of an opposition senator. A previous Commissioner of Police says there is nothing in that report, no evidence. It's just an intelligence report. We have written a letter to the Commissioner of Police consisting of 7 pages answering every allegation to show the allegations are false. The Commissioner of Police got our letter and promised to respond and has not responded. What must this Minister of Government do? Should he allow the state which was at fault in causing his damage, in causing his reputation to be damaged, should he, because he's a minister of government, say, well, listen, the state breached my duty and I am a minister and my reputation is damaged, but I cannot do anything about it. So we have pointed out to the minister that in the United Kingdom, there was a recent case. I'll refer to the full name of the case, but it's a case of Bloomberg. And it was decided by the Supreme Court of the United Kingdom, which comprised the same judges who sit in the Judicial Committee of the Privy Council. And that case decided, in effect, that if police is investigating someone and the police has information and the person is not charged, and that information is leaked to the public, having regard to the right under the European Convention on Human Rights to privacy, and a civil wrong has been committed against that individual, and that individual can file a case against the Crown, the state, in order to get redress. So I will come to that. We have written a pre-action protocol letter to the Attorney General, who represents the state on behalf of the minister. And I want to make it clear that when Minister Foster Cummings filed his claim against the state, it is not a personal claim against the Attorney General. Under the laws of Trinidad and Tobago, under the State Liability and Proceedings Act, if you have an ordinary civil wrong which is called a tort and it's against the state, you have to file it against the Attorney General as representing the state. Similarly, if there is a breach of a fundamental right and you have to file for constitutional relief under Section 14 of the Constitution of Trinidad and Tobago, you have to file a claim against the Attorney General representing the state. So when Minister Cummings filed his case against the state of Trinidad and Tobago, it would be a claim against the state, not a personal claim against the Attorney General or any of his cabinet colleagues. It is a case against the state, and the only way he could file that claim against the state is against the Attorney General. So let me give you an example which you probably know about. In 1975, when a lawyer was in prison for contempt, although it was a judge who did the order, who imprisoned the lawyer, his claim for constitutional relief had to be against the state. So it had to be a claim against the state. And that is why all constitutional actions in Trinidad and Tobago against the state is filed against the Attorney General, and all civil claims, torts against the state is filed against the Attorney General. So we, on behalf of Minister Cummings, had to write to the Attorney General as representing the state to point out to him that the state has contravened the rights of the minister, and unless this is corrected, the minister will have to go to the court to get redress against the state for the violation of his rights. So what I want to do now, having given you the overview, I want to give you the summary of the background facts, and then I'll give you what steps have been taken and what steps are intended to be taken. So in 2019, that secret special branch report was prepared. And as I told you, the minister did not know anything about that report. He was never consulted. And up to today, he has not been consulted or asked or interviewed to answer any of those allegations. But we, on his behalf, has answered those allegations to the Commissioner of Police. Before that report got into the hands of the opposition senator, the Commissioner of Police and the Special Branch had the sole and exclusive control and possession of that Special Branch note or report. It is called a report. I call it a note because it was only 1.5 pages. But whatever name we call it, you know what I'm talking about. So such confidential documents held by the special branch are regarded not only as secret in law, but as private and confidential. And therefore, members of the police service and members of the special branch would know that if you publish that information would damage the reputation and character of Minister Cummings. But the note ended up in the hands of the opposition senator, and at a public meeting in 2022, the minister, on the 5th of May 2022, the minister read from that report. She said she had a copy of the report. She knew the report. She said the police are investigating the allegations in the report. The effect of the senator publishing this secret special branch note meant that the opposition senator published uninvestigated and unsubstantiated allegations made against the minister and published it to the entire country and to the world. Now, the opposition senator would have known that this was a secret report or secret note of the special branch, because headed on that note was in red, secret. And the opposition senator is an attorney at law, and the opposition senator would know, or would be presumed to know, the consequences of someone publishing a secret and confidential report. But that is a matter for the libel action against the senator. This minister, in addition to being a minister of government, holds a Bachelor of Science degree in political science from the University of the West Indies and an Associate of Arts degree in cooperative studies from the Cipriani College of Labor and Cooperative Studies. In 2021, he attained a Master of Business Administration with specialization in leadership, innovation, and entrepreneurship from the Anglia Ruskin University. This minister feels very passionate about his character and reputation. Following the leak of this confidential information by the opposition senator, that High Court proceedings has been against the minister was commenced, and that is pending. And the question, as we say, is what the minister did after filing the claim against the opposition senator, because the minister wanted to get some form of redress in addition to whatever redress against the opposition senator. So the minister, through his lawyers, wrote to the Commissioner of Police asking the Commissioner of Police to correct the baseless information. And as I told you, that the Freedom of Information Act gave the Commissioner of Police the power to do that. That first letter on behalf of the minister was written on the 3rd of May, 2023. The Commissioner of Police did not respond. The minister, by his attorney at law, had to send a follow-up letter dated the 10th of July, 2023, asking the Commissioner of Police to respond. On the 7th of August, 2023, a letter was received from the legal unit of the TTPS with a request for an extension of time to the 21st of August, 2023, in order for the Commissioner of Police to provide a response. On the 9th of August, 2023, the minister's attorneys at law agreed to that extension. There was no response as promised by the legal unit on the 21st of August, 2023. An email was then sent on behalf of the minister to the TTPS legal unit dated the 21st of August, which requested a response from the Commissioner of Police. The legal unit responded and stated that the minister would send a response by the end of that week. That week passed, months passed, a year has passed, and there has been no response from the Commissioner of Police. Now, at the time of the compilation of the Secrets of Special Branch note, as I told you, in 2019, the Commissioner of Police was Mr. Gary Griffith, who served as Commissioner of Police from 2018 to 2021. Now, as a former Minister of Government, I know it doesn't mean to say that Commissioner of Police Gary Griffith knew of the compilation of that note by the Special Branch, or he knew of it at the time, and he must have known of it after it was compiled, and probably after it was disclosed. So I can't help you with that. He was succeeded after 2021 by Commissioner of Police MacDonald Jacob, acting, who served as Commissioner of Police until 2022. Since 2022 to now, the Commissioner of Police is Mrs. Erla Haywood Christopher. So that gives you an idea of the timelines. Commissioner of Police Gary Griffith, who, as I said, was Commissioner of Police in 2019 until 2022, gave an interview on I-95.5 on the 10th of May 2022. He was asked his personal view of this Special Branch report or note, and his response was, his personal view was there was no fact, there was no evidence, and there was nothing to accuse anyone. Those were his words. Based on those answers from a Commissioner of Police who must be presumed to have seen that note, seen whatever evidence it was, he said, no fact, no evidence, nothing to accuse anyone. The answers given in the radio interview by Mr. Gary Griffith was also the subject of an article on The Guardian entitled Griffith on Special Branch Report on Cummings, It's Not Fact or Evidence. The Prime Minister, Dr. Keith Rowley, also commented on the publication of the contents of that Special Branch report. In the Guardian report, it was reported that he stated as follows. Rowley accused the United National Congress of acting irresponsibly and unethically in using a Special Branch report for political advantage. He said the opposition leader ought to know that the information contained in such a report is unsubstantiated. He said that all Special Branch reports are confidential and require further investigation. The Minister explored all efforts to get the Commissioner of Police since 2023 to correct the official records of the TTPS in accordance with the provisions of the Freedom of Information Act. Having given the Commissioner of Police a year to correct the records, the Minister acted unconsciously to his prejudice, because if he had to file a judicial review application against the Commissioner of Police, he had to file that judicial review application within 3 months of the date he made the request. So after a year, he cannot file a judicial review application against the Commissioner of Police, because it's against the law to file it. He would not get leave, and even if he gets leave, he would not get any relief. So the job we had was having, and I could understand what the minister was trying to do, he was trying to avoid having to file any claim against the state. He was trying to get the Commissioner of Police to do what was right and to correct this injustice done to him. So having not filed it on time, our task then was to do research to see what he can do. And with the able team of lawyers that I have assisting me, what we did is that we explored the research to see whether the state had a duty in law to protect the personal information of the minister and not allowing it to be disclosed to the public through an opposition senator. We also had to explore that if it is that the police was investigating allegations and they admitted that they were still investigating the allegations, could the police lawfully cause that information to be published before the person was charged for an offense? And the law is that we found that there's a legitimate expectation in favor of an individual when the police is investigating a matter and before the police charge the individual, for the police to keep that, the police has to keep that information private and confidential, and they must not allow that information to be leaked to the public. And if the police does that, there are two things that can arise. One, there is a tort, which is a civil wrong, called the misuse of private information. And there is a civil wrong known as breach of confidence. And in Trinidad and Tobago, as before the European Convention on Human Rights, there's a constitutional right which every individual in Trinidad and Tobago enjoys, the right to privacy, the right to private and family life. So we advise Minister Cummings that if he wants to get relief against the state, he can file a claim against the state, claiming that the police, the state, contravene his common law rights in breaching his right and they misuse private information and they breach his confidence and they contravene his right to privacy. Now, sometimes when lawyers have to make that decision, they use the principles of law which have never decided that particular fact or that particular issue, but they construct a legal argument to get the court to make law. Fortunate for us in this case, the law has already been settled. And the law has been settled in a case called Bloomberg LP versus ZXC. The reference is 2022, UK, which is UK, United Kingdom, SC Supreme Court number 5. That case decided that where a police report contains personal defamatory information of an individual, the person subject to that investigation has a reasonable expectation to privacy. The Supreme Court decided in that case, where there is a leak of that information, the leak constitutes the tort of misuse of private information and breach of confidence, and also a breach of the right to privacy contained in the European Convention on Human Rights. Now, those of you who are not lawyers but who follow the law, you would see that in every case that is decided in the Privy Council, they are the same judges who sit in the Supreme Court of the United Kingdom. In other words, the head of the Supreme Court in the UK now is Lord Reid, and you will see that he sits very often in decisions in the Privy Council. So applying those principles decided by the Supreme Court in the United Kingdom in the Bloomberg case, the legal team advised the minister that he has an unanswerable claim against the state for the breach of his fundamental right to privacy and the torts of misuse of private information and breach of confidence. And further, he is entitled to a declaration that the torts of misuse of private information and breach of confidence were committed against him, and he is entitled to a declaration that his right to privacy was contravened by the state. He was also advised that the court can award him general damages and can also, in the circumstances of this case, have regard to the conduct of the state, he would be entitled to an award of vindicatory damages for the breach of his constitutional rights. That means the ordinary damages and another set of damages added to that in order for the court to say totally against what was done to the minister. Based on that advice given to the minister, the legal team wrote a pre-action protocol letter to the state, informing the state of the damage done to the minister's character and reputation. The minister indicated in that pre-action protocol letter that the minister would seek relief from the court to get the court to vindicate his character and reputation by making declarations and an order for damages. As I stated to you, in Trinidad and Tobago, a claim against the state in respect of these civil wrongs and constitutional breaches must be filed against the Attorney General, and I'll give you the reference, the State Liability and Proceedings Act, Chapter 802, Section 19(2) of that Act, in respect of the torts, in respect of the constitutional claim, Section 14 of the Constitution of Trinidad and Tobago. The requirements of the law, therefore, demanded that the pre-action protocol letter be issued to the Attorney General of Trinidad and Tobago as representing the state. That letter was sent to the Attorney General of Trinidad and Tobago, indicating to the Attorney General that unless the state responds in a positive way, our clients would have no alternative but to consider filing a claim against the state. I wish to make it clear that the minister made it clear to us that he's not interested in getting damages for himself. But what he wants is that this wrong was not only done to him, but it was done to all of his constituents. It was an attack on him and on his constituents. And he said that I could announce today that any damages he gets would be put in a special fund for the benefit of his constituents, and in particular the young people of his constituents, in order to access that fund. That monies that he gets from the state would be used solely for the benefit of his constituents. As I explained to you, the state of Trinidad and Tobago, in a claim, has to be filed against the Attorney General. So let me explain that a little bit to you. The state of Trinidad and Tobago functions in three arms. There are three arms of the state. You have the executive arm, which is the government, the cabinet, the police service, the prison service, things like that. You have the legislative arm, which is the parliament, and you have the judicial arm of the state. So the minister cannot file an action against the judicial arm of the state because the judicial arm of the state has not violated his right. He cannot file an action against the legislative arm of the state because the parliament has not violated his right. He can only file an action against the executive arm of the state because it's the executive arm of the state through the police service have contravened his rights, his constitutional rights and his common law rights. Now, as a former Attorney General, I have a duty to tell you there is nothing wrong in the special branch gathering intelligence. That is a function of intelligence gathering units throughout the world. So they can gather the intelligence, they can assess the intelligence, and that is very important for the security of the state. But what intelligence units cannot do lawfully is to allow that private and confidential information to be leaked to the public so it could be published. The reason for that is that intelligence units like the special branch collects information based on hearsay most of the time. What somebody say, we will probably investigate, but will want to assess the intelligence. So they do not collect the evidence in accordance with due process of law. Most of the evidence collected, or most of the information collected by intelligence gathering units throughout the world are not admissible in a court of law, based on pure allegations. So I am not saying that the special branch cannot do that. But the evil in this case is not the gathering of the information. The evil in this case is the publishing the private and confidential information. As a matter of fact, the special branch may be compiling information on me. I won't know. They're entitled to do that. They're entitled to see what I am doing, whether I'm breaking the law, etc., and then they could advise the police. And they're entitled to do that about individuals, whether it's gangs, whether it's individuals, whether it's politicians. So they can gather, that is their function. But they cannot publish it to damage the character and reputation of individuals. That is unlawful. That is unlawful both in civil law and in criminal law. So the state of Trinidad and Tobago is responsible for the unlawful and unconstitutional breaches by the police service and the special branch. And they are responsible in law for the fact that this minister had made every effort to get the Commissioner of Police to correct this information, and it has not been corrected. The publication of the contents of this secret special branch note to the opposition senator scandalized the minister, caused him reputational damage, caused him and his family distress and embarrassment, and this also caused distress and embarrassment to his constituents. So could you imagine, since the publication of this note to the public in 2022, the distress that this minister has gone through, is going through, his family is going through, his constituents are going through, especially with the fact that the police still are saying, after 5 years, 6 years, that they are still investigating these allegations. The police are still maintaining that they're investigating the allegations. So we are saying, keep on investigating, but until you get any evidence to charge us, clear our name. And let me tell you what the police has been saying to the press. But before I tell you that, this report was compiled in 2019, 5 years ago. My client has not been contacted to answer any of the allegations, but the police is maintaining they're investigating, and they're investigating for the last 5 years, and they're still continuing. The Trinidad and Tobago Police Service informed the media that the police investigations are continuing. And let me give you some of the details, just three. The acting commissioner of police at the time, MacDonald Jacob, in a response to a question from the media, acknowledged that the special branch note, which was then in the public domain, was authentic. So we get an admission that this note existed. And some of the responses given to the Trinidad and Tobago Police Service to question asked by the media are as follows. In the Guardian report of the 19th of April 2023, the Deputy Commissioner of Police Intelligence and Investigation stated that the investigations were still in progress. In the Newsday dated the 30th of May 2022, the Commissioner of Police confirmed that the Trinidad and Tobago Police Service investigation into the allegations are still being conducted. In the Newsday dated the 2nd of June 2022, at a weekly media briefing on the 2nd of June 2022, the Trinidad and Tobago Police Service confirmed that the TTPS investigations are still continuing. Is it rare 5 years with a note compiled in 2019 with a former commissioner of police saying there is no evidence that you could say you're still investigating, but you still haven't spoken to Minister Cummings? 5 years have elapsed since 2019. The minister has not been interviewed by the police in respect of any allegations during those 5 years. The Commissioner of Police in 2019, Mr. Gary Griffith, stated in 2022, the Commissioner of Police, who was Commissioner in 2019, stated during an interview in 2022 on radio I-95.5 that an intelligence report like that one was just that. It was no fact, it was no evidence, it was nothing to accuse anyone. So we have a situation in which the Commissioner of Police is basically telling the minister, I am not responding. The records may be inaccurate, but I'm not responding, I'm leaving it like that. The minister continues to suffer distress as a result of this report still being considered to be being investigated. So, it is in that context we wrote the pre-action protocol letter. And I want to tell you, I think the minister has a duty to himself, his family, and his constituents to take steps to have the court vindicate his reputation by granting him the appropriate relief. I want to tell you basically what we said in the pre-action protocol letter in point form. That pre-action protocol letter sent to the Attorney General was dated the 18th of October 2023. And we made the following points to the Honorable Attorney General. The secret note of the special branch was in the exclusive and confidential possession of the state. The contents of that note, which contained baseless allegations of wrongdoing against the minister, was disclosed and disseminated to an opposition senator by Department of the State through the servants and agents of the state. The disclosure and dissemination by the state to the opposition senator of a secret special branch note was in breach of the common law principles of the torts of misuse of private information and breach of confidence, and a breach of the constitutional right of the minister to privacy guaranteed in Section 4C of the Constitution. The wrongful identification by the state of the minister as a person the subject of police investigation and the disclosure by the state of such information to the public, both in circumstances where the police investigations were pending and were not yet completed. According to the statements made by the police service, the police continued and are continuing to investigate the matter, and therefore the police had a duty to ensure that the private and confidential personal information contained in that secret special branch note relating to the minister was not disclosed or disseminated to the opposition senator, because it would have been known, reasonably known, that it would have been made public. The minister had, and he continued to have a right to, and a reasonable expectation of privacy in respect of the information relating to police investigations against him, which was being conducted at the time of the disclosure of the information to the opposition senator, which investigations are continuing and are not yet completed. The expectation of privacy in respect of that information, private information relating to the minister, impose an obligation in law and a responsibility in law on the TTPS, headed by the Commissioner of Police, who had command and superintendence over the officers of the TTPS, to have kept such information secret, private, and confidential. The principal and primary holder of the information was the TTPS, which was an organ of the state, and consequently, all organs, departments, servants, or agents of the state were all fixed with a non-delegable obligation and responsibility to keep such information, as in this case, secret, private, and confidential. The revelation of the secret note of the special branch and its contents by the state through its organs, servants, and agents of the state could only have occurred because there was a breach of the state's obligation to the minister and of the minister's expectation in respect of privacy by the servants and agents of the state. That was sent to the Attorney General, and the Attorney General responded. The Attorney General, in his response, and he had a duty to respond, he has a duty on behalf of the state to say what his case is. And there was nothing personal against the Attorney General. He's doing his duty for the state. The Attorney General responded, and he said on the 23rd of October 2023 that the state could not be liable for the disclosure of the information in the secret special branch note because the minister is unable to give the names of the officer or the officer of the state who caused or was responsible for disclosing the secret special branch note to the opposition senator. So we now have to respond to that. So what the Attorney General was saying, that unless Minister Cummings know the name of the officers of the special branch or the police service who disclosed that to the opposition senator, he has no claim. So we responded and said, pointed out to the Attorney General that at paragraph 26 of our pre-action protocol letter, we stated that based on established principles of law decided by the Court of Appeal and the Judicial Committee of the Privy Council, there was no legal obligation on the minister to know the names of the officers of the state who caused the disclosure or who were responsible for the disclosure of the secret information to the opposition senator, because the undisputed evidence in this case on the admission of the police was that the police investigations were continuing, and the undisputed evidence in this case was that the state was in the exclusive possession of the information before it was disclosed to the opposition senator. By letter dated the 27th of October 2023, the attorneys at law on behalf of the minister responded and pointed out the attorneys at law on behalf of the minister pointed out in response there are two decisions of the courts which supported the claim of the minister. The legal team cited to the Honorable Attorney General two decisions of the Court of Appeal. Those cases are Patrice Karim versus the Attorney General of Trinidad and Tobago, Civil Appeal number 71 of 1982, and the Appeal of Justice of Appeal Jamada in Civil Appeal number 113 of 2009, Antonio Webster versus the Attorney General, support the submissions which we made in our pre-action protocol letter. Well, the Attorney General responded to that letter, and he came up with another point. The Attorney General then, in a letter dated the 4th of December 2023, stated that since no department or organ of the state or servant or agent of the state was authorized by the state to disclose the contents of the secret special branch note to the opposition senator, the state was not liable for the disclosure of the secret special branch note and its contents to the opposition senator. So we responded, and we show the Attorney General authority to answer that. By letter of the 20th of December 2023, we pointed out in that letter, that the case which the Attorney General relied upon was not a case where the state was the employer. That was a case where there was a private employer. And we then pointed out to the Attorney General that in the case where the state is an employer, there are different considerations. And we pointed out a landmark decision of the Privy Council in the case of Thornhill and the Attorney General of Trinidad and Tobago, reported in two weekly law reports, 510 and at page 519, in which the Privy Council decided that police officers of Trinidad and Tobago carry out the essential functions of the executive arm of the state, and the actions of the police service are in effect actions of the executive arm of the state, and the state is responsible for their actions. And there's a recent case which we just found, a case of Akil Charles and the Attorney General, decided by the Privy Council in 2022, references UK PC 49 at paragraph 42. The Privy Council decided that a claimant, like the minister in this case, does not have to assert in a claim against the state in such circumstances that a specific body or specific individuals within an organ of the state is responsible for the breach of the fundamental right, as long as the organ of the state, as in this case, the TTPS, is an organ of the executive arm of the state. So we have shown the state, in our respectful view, that it hasn't got a case against the minister. We have firm instructions, and we have drafted the claim, and the claim is going to be filed. The state will have its day in court. We will have our day in court. We have precedent, we have authorities, and it will go to the final court of appeal. Whether that final court of appeal is the Privy Council or the Caribbean Court of Justice, there could only be one decision in this case. In conclusion, the minister's character and reputation was damaged, and it is very important for him to have redress for the damage to his character and reputation. On becoming a member of parliament, the minister took an oath to uphold the laws and the constitution of the country. When he became a minister, he took a similar oath. In the preamble to the Constitution of Trinidad and Tobago, it states that men and institutions remain free only when freedom is founded on the respect for moral and spiritual values and the rule of law. The minister is committed to the rule of law, and he expects the rule of law to be held by the state in relation to him. An essential ingredient of the rule of law is that no one is above the law. The minister believes he and any public officials are not above the law, and it is a police service corrected, amended, and even deleted so that his reputation can be vindicated. And if that is not done, he would be entitled to seek relief in the constitutional courts and also for common law relief. It's in that context he believes that since the Commissioner of Police, who acts on behalf of the state, has not taken steps to correct the inaccurate information now stored in the official records of the police service in order to vindicate his character and reputation, he is left with no alternative, have regard to the duty to himself, his family, and his constituents. The minister feels justified in launching proceedings against the state to get the appropriate relief so that his character and reputation can be vindicated. The minister is adamant to vindicate his character and reputation. He has a passionate belief that a person's good character and reputation is the greatest asset any person can have. He has a passion to safeguard and protect his reputation because he is passionate in his belief that his character and reputation is the most valuable asset he has. His character and reputation have been attacked by the state as a result of the failure of the state to do its duty towards him. The failure of that duty to the state resulted and continues to result in his character and reputation being attacked. Therefore, he has a duty to vindicate his character and reputation. And we are reminded of a well-known words of an international businessman, Mr. Richard Branson, who said this about a person's reputation. I quote, "Your brand or your name is simply your reputation. You have to fight in life to protect your reputation, as it means everything. Nothing is more important." Thank you very much. I would invite any questions the media has, and I will also invite Mr. Bisesa to join me to help me with any questions. Right?
Thank you very much.
Right, good evening again. And that was the media conference as to the explanation as to why by Ramesh Lawrence Maharaj as to why Foster Cummings should be vindicated. And to you, the members of the public, yeah, I mean, if some of you may have come on a little late, these are the key points that you should take cognizant of. One, the special branch report was leaked to the opposition Senator Jayanti Lakshmi Dayal, who read it out on a political platform. As to go in sync with the timeline, Cummings' attorney have been seeking to correct the false information contained in the report, but no response have been received from the TTPS. Cummings is suing the state for breach of its constitutional rights and the thoughts of misuse of private information and breach of confidence. So that is the next thing, and the legal action is expected to begin soon with a claim against the Office of the Attorney General drafted and set to be filed in the High Court within the next week. So many of you that is now catching on, these are the points that you must pay attention to. Again, the information was leaked on a public platform by Jayanti Lakshmi Dayal. Cummings' attorney has been seeking to vindicate him for a lawsuit for breach of his constitutional rights, misuse of personal information. And the thing about it is this, people. That is the same thing that we was saying. Or you didn't find it funny that every time somebody is held or charged, or you've seen it on the front page, or you've seen it showing up all over social media. Now I'm glad this thing happened to a certain degree, because I was wondering about that. Some of you may be held for a crime and haven't been charged, haven't been convicted as yet. And we was wondering what could have been done concerning this. And you would have seen that, again, Ramesh Lawrence Maharaj would have found the law concerning that. Now again, my name is Renison Jeffrey. This is the Workers' Rights Platform. Like, share, and subscribe.